Our last reader for the evening is going to be Phillip Margolin. Phillip has been a Peace Corps volunteer, a school teacher, and is the author of 17 New York Times bestsellers. During a quarter of a century as a criminal defense attorney, Phil handled 30 homicide cases, including 12 death penalty cases, and argued at the United States Supreme Court. His novel, The Last Innocent Man, was an HBO movie, and Gone But Not Forgotten was a mini-series on Lifetime Channel. Heartstone, his first novel, was nominated for an Edgar. Executive Privilege won the Spotted Owl Award for Best Northwest Mystery. Wild Justice and Lost Lake were nominated for the Oregon Book Award, and Phil's short stories were included in the anthology The Best American Mystery Stories of 1999 and 2010. Phil is co-founder of Chess for Success, a nonprofit that uses chess to teach elementary school children study skills.
So my new book, Worthy Brown's Daughter, is my 18th, but it's really different from my other books. All the other ones are contemporary legal thrillers, usually the lawyer and the murder, but they're set in the present. Worthy Brown is set in 1860, the second year of statehood. And it was inspired by a real case that I read about in the 1980s. I've been working on this book on and off for 30 years. It's a real labor of love. The case that I stumbled across is called Holmes versus Ford, and it's the only Oregon case dealing with slavery. Colonel Nathaniel Ford owned the Holmeses. Robin and Polly were the parents, and they had 5 children in Missouri. And the economy tanked in Missouri, and so he decided that he was going to move from Missouri to the Oregon Territory, and he gave the Holmeses a choice. He would sell them in Missouri to someone else, or if they came with him and helped him establish a farm in Oregon where slavery was illegal, he would free them. Well, the family came with Ford to Oregon, and they did help him establish a farm. It's where Rick Reel is right now. But he reneged on part of the promise. So he let the 2 parents go and a young child, but he said, you know, you have 4 other kids, and I clothed and fed them when they were real young and were no use to me. So now that they're older, I want to get some benefit out of them, so I'm not going to give those kids back. Well, Oregon was really racist in the 1800s. We're the only state in the Union that had an exclusion clause in our Constitution that barred free Negroes not living in Oregon when the Constitution was passed from living here, owning property, making contracts. So you had these 2 illiterate blacks, and because it was illegal to educate slaves, they were both illiterate, and they had to get the assistance of a white lawyer to sue Ford to get the kids back. The judges didn't want to handle the case because Ford was very powerful. He was a member of the legislature. He was actually supposed to be the first judge in Oregon. He was offered the spot and turned it down, but he was very influential, a member of the legislature, and the judges just didn't want to mess with the case. Oregon was a territory, and the judges were appointed from back east. So George Williams, a New Yorker, was appointed to be the head of the Chief Justice of the Oregon Territorial Court. He didn't know anyone here. He came out and in 1 week ruled that Ford had to give the kids back. However, one of the children had died while in his custody. And I thought this was just a heartbreaking situation. I have 2 kids. I tried to imagine what it would be like if someone was stealing my children. Everyone knew who it was, and I couldn't get them back because of my skin color. And so I thought this would be a really interesting basis for a novel. And so in the early 1980s, after learning about this case, I started thinking about writing a book that would be set in the 1800s. But I had a couple of problems. The first is I didn't know anything about history. I had one course in college. So I didn't know, I had no idea what it would be like to live in 1860. You know, what if you wanted to get a drink of water? Did they have faucets? I mean, how did you do it? Just the real basic things. They have toothpaste. I mean, what, you know, so fortunately my law office, and I practiced law for 25 years from about 1970 to 1996 when I quit the right full time. It's just a couple blocks from the Oregon Historical Society. So when my practice would be light, if I had an afternoon where I could, you know, didn't have clients or anything to keep me busy, I'd wander over there and I'd spend a couple hours researching not only what it was like to live in 1860, but in my book, and it's, again, I moved it from the 1840s and 50s to 1860, the second year of statehood, and I changed it from a family to Worthy Brown, who was the father, and Roxanne Brown, his 15-year-old daughter, who are brought from Georgia by Caleb Barber, who was a very powerful Oregon attorney. And in the book, Barber frees Worthy, but insists on keeping the daughter basically as a slave, and he needs to find a white lawyer to help him. The other main character is Matthew Penny. Matthew is a young lawyer who convinced his wife to come with him on the Oregon Trail to start a new life in the territory, or I mean the state, even though she was perfectly happy staying in Ohio with her family, and she dies on the trail. And so when he gets to Oregon, he's very depressed, he's grieving, and for various plot reasons, he agrees to help Worthy try to get his child back by suing Caleb Barber. So what I not only had to find out what it was like to live in 1860, but what it'd be like to be a lawyer in 1860. You know, what was there any difference? I had no idea. And so while I was researching, I fortuitously stumbled across the memoir of one of the people I think is the most interesting people in the history of the United States. Nobody knows who he is. And so I'm going to ask you if any of you have heard of this guy, but if you don't feel bad or stupid, because the first time I gave this talk was as the keynote speaker at the Federal Court Historical Society dinner. 200 lawyers or people connected with law in the federal court system who were also interested in history. And I think out of about 200 people in the ballroom at the Governor Hotel, I think 1 or 2 people raised their hands. So who here has heard of Stephen J. Field? See, nobody knows. This guy is the most amazing. Have any of you ever seen the Maverick show? You remember Brett and Bart Maverick? Okay, I mean, for those of you, I'm really old, so. Well, I mean, this guy's life is just like mind-boggling. He was the first United States Supreme Court Justice from the West. Abraham Lincoln appointed him. He was the longest-serving Supreme Court Justice until William O. Douglas, and he's the only United States Supreme Court Justice to be arrested for murder while he was sitting on the bench. His life reads like a Western novel. He had shootouts, duels. I mean, it's just how did he get on the California Supreme Court where he served before getting on the U.S. Supreme Court? The West was different than it is now. David Terry, who was the Chief Justice, was crazy as a loon, fought a duel to the death with a U.S. Senator and killed him, and because dueling was illegal, he had to get off the court. That provided a vacancy, and so that's how Field got on the California Supreme Court. So while I was going through this memoir, which is absolutely fabulous, I mean, I actually ran out and bought it as soon as I finished it because it's so amazing. I ran across a chapter in there which had an incident that paralleled something in an incident in my legal career. So I'm going to briefly tell you about my experience and how I handled this in the 20th century, and then I'm going to read you about how Field dealt with a similar situation. You'll see there's some real interesting differences. So there was a time when if you were arrested for driving under the influence and the police officer gave you a ticket and checked the wrong box, you could get the case dismissed. It was a legal technicality that they eventually closed that loophole, but there was this brief period where that was the law. So I had a client who lived in Portland and had been given a ticket for driving under the influence in another county where I rarely practice, and the police officer checked the wrong box, so I said, don't come down to this county, stay up in Portland, because they could serve him. They could re-serve him if it was physically in the jurisdiction. Said, you go up here, I'm going to move to, we'll get the case dismissed. So I go in front of a judge I had never heard of him. I never met him. And I get up and he called the case, and I said who I was, and he said, well, where's your client? I said, well, I told my client to stay up in Portland because I'm moving to dismiss the case. And I had a memo and all the relevant cases. And the first time I realized that something was going to be a little amiss was when he said, well, I don't know how you do things in Portland. But here, and I said, huh, that's interesting. So he was just furious that I was moving to dismiss the case, and told my client not to come down. I said, well, you know, this is the law. So he looked at the DA and he said, is he right? And he said, yeah, he's 100% correct. So he said, well, I'm going to tell you this, Mr. Margolin. If you insist on dismissing this case, moving to dismiss this case, I'm going to order the DA to have a trooper go up to Portland and serve your client again, and your client's going to have to pay all the expenses. Now, that's totally illegal. I mean, just it's not even like within the pale of legality. And I said, well, I said, I'm still going to insist on dismissing the case. I was very, quiet about it. I didn't say anything mean. And so eventually he was forced to do that. Now, what concerned me was not me, because I was pretty confident in my abilities, but I was wondering, what if I was a brand new lawyer who practiced in front of this guy all the time? Would I have knuckled under? Would I have been so afraid of having to come in front of him all the time and having him be angry at me that I would sell my client out? So I went to the clerk. This is how I handled it in the 20th century. I went to the clerk's office. I got a tape recording of everything that was said in court to make sure I heard what I thought I heard. And then I didn't want to mess with this guy's career if it turned out he was having maybe he had a fight with his wife or went to the doctor and got a bad diagnosis. So this is what I did in the 20th century. I called and asked advice from a number of lawyers who practiced in front of this guy, and I asked them what he was like, and they all said he's an asshole. He does this stuff all the time. He's really mean. So I then, in the 20th century, I wrote down an account of what had happened in court, included the tape recording to show that I wasn't making it up, and sent it to the Judicial Fitness Committee, and eventually he had to write me a letter apologizing. Okay, 20th century. Now I'm going to read you about a run-in that Field had with Judge William Turner. Field was originally from New York. He moved out to California and practiced in Marysville, California. And this is what happened in the 1850s when he had a run-in with a judge. Towards the end of May 1850, William R. Turner, who had been appointed judge in the 8th Judicial District of the state by the first legislature which convened under the Constitution, made his appearance and announced that he intended to open the district court at Marysville on the first Monday of next month. We were all pleased with the prospect of having a regular court and endeavored as far as lay in our power to make the stay of the judge with us agreeable. Now, I had been in the habit of receiving a package of New York newspapers by every steamer, and among them came copies of the New York Evening Post, which was at that time the organ of the Free Soil Party. When Judge Turner arrived, I waited on him to pay my respects and sent him the various newspapers I had received. He had lived for years in Texas and approved that, and as approved, was a man of narrow mind and bitter prejudices, and he seems to have had a special prejudice against New Yorkers and regarded a free soiler as an abomination. I have been told, and I believe such to be the fact, that my sending him these newspapers, and particularly the Evening Post, led him to believe that I was an abolitionist, a person held in special abhorrence in those days by gentlemen from the South. At any rate, he conceived a violent dislike of me, which was destined in short time to show itself, and caused me great annoyance. What was intended on my part as an act of courtesy turned out to be the beginning of a long, bitter, and on his part, ferocious quarrel. Now, shortly before the opening of the June term of court, Captain Sutter comes to Phil and asks him if he will represent him in a case. He's being sued by a man named Cameron. Well, Phil was getting ready to go back east, and he really didn't want to do this, but Sutter was a friend, and he finally sort of begged him to do it. So finally, Phil gave it partially. He said, "I'm not going to be your lead lawyer, but I will second chair this case." So soon after the opening of court, sometime during the first week, this case was called, and a preliminary motion was made by Sutter's attorney, and was decided against him. Mr. Jesse O. Goodwin, a member of the bar sitting near, said to me that the Practice Act, passed at the recent session of the legislature, contained a section bearing on the question, and at the same time handed me the act. I immediately rose and, addressing the court, remarked that I was informed that there was a statutory provision applicable to the point, and begged permission to read it, and commenced turning over the pages of the act in search of it, when Judge Turner, addressing me and apparently irritated, said, in a petulant manner, "The court knows the law. The mind of the court is made up. Take your seat, sir." Well, I was amazed at hearing such language, but in a respectful and quiet manner stated that I accepted to the decision and would appeal from the order. The judge instantly replied in a loud and boisterous manner, "Fine that gentleman $200. I replied quietly, "Very well, sir." He immediately added in an angry tone, "I fine him $300 and commit him to the custody of the sheriff 8 hours. I again replied, "Very well," and he instantly exclaimed in the same violent manner, "I fine him $400 and commit him 12 hours. I then said that it was my right by statute to appeal from any order of his honor, and upon my statement he flew in a perfect rage and in a loud and boisterous tone cried out, "I fine him $500 and commit him 48 hours, turn him out of the court," and I left the court. Now, I remained in my office for the remainder of the day and wrote out a full statement of everything that happened, just like I wrote out my statement. And I had it verified by a number of persons who were eye-and-ear witnesses, and soon out a writ of habeas corpus returnable before Henry P. Horn, the county judge. And the writ was executed forthwith, and the same evening I was taken before Judge Hahn. I was, of course, at once discharged, but the matter did not end there. An excited crowd was present, and as I left the courtroom, they cheered enthusiastically. I thereupon invited them to the Covillard House, a public house in the town, and directed the keeper to dispense to them the good things of his bar. The champagne was accordingly uncorked without stint, and the best Havana boxes were soon emptied of their most fragrant cigars. Whilst the boys were thus enjoying themselves, Judge Turner entered the Covillard House perfectly furious and applied obscene and vile epithets to the county judge, declaring with an oath that he would teach that fellow that he was an inferior judge and that the witnesses before him were a set of perjured scoundrels who should be expelled from the bar. Similar threats were made by him in various different saloons in the town, to the disgust of everyone, and that evening he was burned in the public plaza in effigy. On the Monday following, June 10th, which was the first day of which the court was held after the scenes narrated, Judge Turner ordered that Judge Horn be fined $50 and imprisoned for 48 hours for his judicial act in discharging me from arrest. At the same time, he ordered that I should be re-imprisoned, and that Mr. Mulford and Mr. Goodwin and myself should be expelled from the bar, myself for suing out the writ, and those two gentlemen for being witnesses on its return, under the pretense that we had vilified the court and denounced its proceedings. Judge Horn paid his fine and left the courtroom, and I was again taken into custody by the sheriff. Immediately afterwards, I sued out another writ of habeas corpus, and while before the court arguing for my discharge, under the writ, the sheriff entered, declared his